I'm Kellen Bryant, Florida Bar Board certified elder law attorney, and I've helped thousands of families get power of attorney in place. And today I'm going to walk you through the mistakes you should avoid or face costly court processes and the exact steps I would recommend to approach getting a power of attorney in place. Let's get into it. First off, you may think a durable financial power of attorney is some form you can download for free online. The problem is with online forms, there is no liability for producing a bad form. And a lot of times the user, when a bad form is in place, there's no feedback loop or accountability for it because it's free. Everyone knows that you're taking a chance by using a free form. And so what a durable power of attorney really does is, yes, the form will say, I, dad, name son as power of attorney. And then it's hopefully signed correctly. And then you disseminate that and distribute that to all the places where you want that power of attorney to work. However, the middle part of that document needs to have, in Florida, exact wording in order to take certain actions. So simple things like operating a bank account, you may get denied right at the front gate, and then you know that power of attorney is not really workable. But there's other actions down the line where that power of attorney online may work, but on this action, but on the action over here, it does not work. So you don't know if you have a bad power of attorney form until it is denied by a financial company and you need an attorney to push it through, and the language in the power of attorney does not work, and your parent cannot sign a new power of attorney because they're long gone, mentally incapacitated. So getting that form, while it seems really simple in practice, getting it right, the meat of that form really counts. And you're looking for an attorney to produce that form so that the insides reflect the attorney's experience in pushing through problems, or when there is problems, the right language that it needs, the document will need to fix problems. And so the durable power of attorney form, if done incorrectly, and your parent can't sign a new one, may require a guardianship to fix. And a court-supervised guardianship could be anywhere between $10,000 and $30,000 to push forward any kind of financial matters you may need. But first, before thinking about this power of attorney form, a lot of y'all will think, hey, I can go to the bank with my mom and dad, and we can just walk into the bank, and the bank will put me on the account. Mom's sitting right there. That is just one sliver of reason you would need a power of attorney. If your parents just have a bank account, that might be sufficient, but may not. A durable power of attorney can have you go through their bank statements, and if you want to cancel something and you can't get the bank to cancel it, you're going to have to go to the company to cancel it. The company could say, hey, you're not power of attorney. Where's the power of attorney? Oh, he doesn't say you can cancel this. So it's very important to have the right worded power of attorney, and it can't just be thought of as limited to the banks. It has to be thought of for a lot of things. I had a case one time where on my client's IRA, which requires a distribution out of each year called a required minimum distribution, the parent the previous year lost mental faculties, and they were unable to initiate the distribution from the IRA. And so what happens is that when you have to take a distribution from the IRA and you don't, you get an excise tax. You get a super tax where that distribution, the IRS is essentially forcing you to take the distribution. If you don't take it, you're going to have to pay a lot of money to the IRS. And just having that power of attorney in place, correctly worded, could have avoided that problem. And the power of attorney needs to say, my agent, that's the person doing the job of a power of attorney, can exercise power over my IRA to get a distribution from the IRA. So the form really does matter. And a lot of times people think very narrowly in terms of this form and say, I need power of attorney over my parent. That's it. But I've had instances where the person with power of attorney dies and there's no backup name. Or I have an instance where a person with power of attorney for their parent moves away and doesn't want to do anymore, and the parent has no one acting for them because they're completely mentally incapacitated. So that's the number one problem I would avoid, is assuming the downloaded durable power of attorney form is sufficient, or the form that you get from the notaries is sufficient, or even a lot of times for folks with less than $500,000, less than $1 million, the power of attorney form you get from estate planning attorneys who don't do public benefits planning may not be sufficient either. It may not be a powerful power of attorney used for Medicaid planning and asset protection planning and probate avoidance. So don't just rely on the forms you can find. All right, the next mistake that I've seen with durable power of attorney and trying to get it for your elderly parents is the child or person looking to help is very pushy for the parent to sign that durable power of attorney. And the perspective shouldn't be, how can I get my parents to agree to sign this in terms of, I got to get this, I got to do this. And you're thinking more self-related. It's, how can I help them help the family situation? That's the correct perspective. And so a lot of times the pushiness is the source of any kind of restrictions that people, or roadblocks that people experience in trying to get power of attorney. So imagine having a document being sprung on you and saying, you need to sign this, you need to sign this. And that's pushy. Most people do not like asked to sign legal documents in their first place, because most elderly parents know what a legal document looks like at this point in their life. And they don't like to be pushed in a direction, especially if they will feel obligated or feel like it's necessary. It also creates a lot of anxiety. It also creates a lot of confusion or stress when somebody is pushing. And when those feelings are around, the natural response is to say no and not listen. So coming at them saying you have to do this is not the right approach. And if you're not the person your parent wanted to be power of attorney, it will take even a further action to push them away from you. They will push away from you if you're not the right person that they wanted. So being pushy does not work from a situational human relationship standpoint. Also, being pushy does not work from a legal standpoint. Attorneys generally represent the client in this context who's signing the document. The client's not going to be you wanting to get power of attorney. It's going to be the client will be the parent signing the durable power of attorney. And if I'm the attorney looking for getting a power of attorney in place for my elderly client, I'm going to make sure that situation's vetted so the person over here has the right intentions, and my client, the parent, protected, and they understand the decisions that they're making, the ramification, the impact of the decisions they're making, and that they understand what this document's going to do, and they understand that this is the right choice for them. So the next problem with being pushy is legal ramifications. In Florida, we have a concept called undue influence, and undue influence means that a person named in the document who has something to gain by signing the document works and actively procures the signing of that document. Courts will overthrow the durable power of attorney under those grounds if it was produced by this undue influence. And so you being pushy legally could cause the durable power of attorney not to work. The third big mistake that I see is once this durable power of attorney is signed, with downloaded, pushed the parent, then the person who's trying to get this power of attorney takes it to a bank or to an insurance company or to a title insurance company to sell property. And the financial company looks at it initially and says, I got to run it by legal. And you, as the one trying to use this power of attorney, tend to get agitated because you don't understand the process. You get agitated because, hey, it didn't work immediately. Hey, I have this is legal, or so you think. And so you'll get angry and and you'll get frustrated. And a lot of times people can't hold their frustration in and continue to be professional and regulate their emotions. And so they're act angry. And then in response, the banker is going to let their legal department know how you're acting. And if you're not acting professional, that gives another reason for a bank or financial institution to say, hey, we know Mrs. Jones, and this doesn't seem right because this person's acting unprofessionally and wild. We can't accept this document. And whether or not that's legally true, they're thinking they are protecting their elderly client from exploitation, because somebody who's generally not looking to exploit another human being won't act crazy and belligerent in front of the bank. So understand that there is a process even after the power of attorney is signed in order to make it work. And even through that process, you may discover that previous step and mistake that I discussed about these downloaded forms and the meat of the legal document do not have what it needs to have in it. And that should be your clue that you need to approach this the right way. So let's work through that. All right, now that we covered what not to do, let's talk about the 4 key points and 4 steps I would recommend as an elder law attorney to get power of attorney in place for your elderly parent. Step one is, before you do anything, you need to talk with your parents and family about who's going to help and how we're going to approach this and whether there is a problem. Approaching this conversation with compassion and restraint and patience is the key. Coming at somebody saying you have to do this, as I've discussed, is not the key. You may even find in this discussion that there is already documents in place, and maybe that's just what we needed to get that first step in the right direction of helping your elderly parents. So now hopefully I'm talking to the dutiful caregiver or the child who's looking to help their parent, not somebody who's trying to push and get what they want. So talk to your parents, talk to them about, how, and with the understanding that removing the financials from their independence, sole independence, is one of the biggest moves that indicate to them that they are going downhill. So when you're a child, you're like, oh, I can drive, I can do this, I can do that. I'm 25, I have cheaper car insurance. For your elderly parent, it's the opposite. I can't do this anymore. I can't do this anymore. I can't do this anymore. And it's the opposite effect. They're getting sadder as they can't do as much. So that's why you need to approach it with compassion and ask from the perspective, how can I help you? And how can I make this as dignified of an experience possible? A lot of times you do need to also extinguish core misconceptions that your parents may have about signing a power of attorney. A lot of people in Florida believe that the power of attorney supplants them, or basically, once I sign this, my signature means nothing. My life's over. My ability to handle my own financials is no more. That is not the case. So power of attorney names a co-pilot in helping your elderly parent with their financials, and has somebody in place that if they were not able to manage their financials, there is continuity. You can continue on paying their bills. So we're not afraid of lights being shut off, scams, you're paying attention. Credit card bills aren't getting run up unpaid with late charges and interest. I've seen property tax not get paid for a period of time. Sometimes it just gets away from somebody. I've seen financial situations where the elderly parent had 10 accounts chasing the best interest rates for savings accounts, and then 10 credit cards over here looking to get the best points and reward points. And they're moving balances all over the place, and it just becomes too much to manage. And that's another thing that needs to be communicated, that, hey, this is a very tough situation that you put yourself in. It's very complex. I'm sure it takes hours to manage this each week. Can I help you streamline this? Because it's going to be a mess for me to handle whenever your time passes. So there's some examples that I would use to talk with my parents. Now the family may need to also be involved as well. Maybe your siblings, maybe other trusted people may need to explain, like, hey, this is what happens when, power of attorney is not in place. It's guardianship, and it costs tens of thousands of dollars in place. You don't lose your independence. We want to help together. So if it's you and your sibling, it's good to come and say, hey, we want to help you. And we don't want it just to be all on one of us. We want to help you. And the person who has power of attorney does not necessarily need to live down the street. The person can live across the country. So the durable power of attorney is not something that you need to have in place with the person immediately next to you. So next step is you need to understand how the durable power of attorney fits in the big picture. So using this durable power of attorney, big picture may be long-term care planning or elderly care planning. Your parent may be needing people come in the home to help them, or go to assisted living, or in the big picture, their help can decline so far where they may need nursing home care. And if you need nursing home care, you need Medicaid planning. If you need Medicaid planning, probably can't sign a new power of attorney at times. And if that power of attorney does not have the correct wording, you may not be able to protect assets from the nursing home because you don't have a good power of attorney. Or if you want to avoid probate, you did all this estate planning, you want to play the estate planning attorney to help set up your accounts the right way. The correctly worded durable power of attorney can give your agent the ability to put money in your living trust to make sure that probate is avoided. And so the big picture of power of attorney, it allows your family to help clean up any estate relating matters that could be a potential for financial loss or financial hazard or stress. And if you don't pull in your family in this discussion, and the right people in the family in the discussion, then you're going to be looked at as somebody who's trying to exploit my mom and my parents. And that can create litigation even if the power of attorney is signed, if we don't have the right people in place to understand what's really going on. What are we looking to accomplish in the big picture? The third step we would use is using a elder law attorney to produce the durable power of attorney document. Now, there's estate planning attorneys and there's elder law attorneys. There's family law attorneys parading as elder law attorneys. And the durable power of attorney document, if the attorney producing it distills it down to just the form and they're not looking to get and create the best form, then you have a problem. And you could have a problem with the language in the middle of the document, because in order to create the best form is the most experience actually using that document in the real world for things that need to be done, such as estate planning, tax planning, business succession planning, management of accounts, insurance, annuity, retirement plans, management of investments, Medicaid planning, changing the mail, doing all those little things that the elder law attorney knows the roadblocks that come up, and the elder law attorneys should be informed about how their language in the document, the blurry, boring language, how it needs to be worded to avoid problems. And frankly, the elder law attorney will see those problems and have to push through them. Sometimes the banks employ people who've only been there for 3 months, or they employ paralegals in Texas who are looking at Florida durable power attorneys who are not attorney who's licensed in Florida. And the elder law attorney needs to have that language down, so if it gets rejected over in this state, they know what to do and their language will prevail without requiring court to solve the problem. Okay, now talking about the language of the durable power of attorney, I wanted to take some mystique out of it and show you some couple durable power of attorney documents that I have reviewed recently. This is one that was pulled off a line, and as you'll see, there is dense language in the minutes. But what is missing is, if we're looking for any kind of long-term care planning, what's missing is the powers to create a trust, powers to do long-term care planning, and so forth. And there's no specifics in the dense legal document. Yes, it says Medicaid, but it doesn't say things you can do to get Medicaid. So that's a hole in this particular online form. Here's one that's old. This old one has quick little sentences, no initials. It was before the 2011 law change, so it didn't require initials. But just for talking about banking, this is what it says in reference to banking. Draw, accept, endorse, deal with any checks, make withdrawals from a savings account or building and loan deposits. And the problem with that is now that the preferred language is to be very specific and only interpret the language of these documents very specifically. So what a bank could come back and read this as, it doesn't say, it says from any savings account, it doesn't say or building or loan deposits, doesn't say anything about being able to pull out of checking accounts, and we're going to reject this power of attorney. And if you look through this, there's, of course, nothing about saying online banking, which is what everyone does not nowadays. And so the banks won't even let you online bank with this, what we have found. And just to show you how antiquated language can become, they're talking about U.S. savings bond known as flowered bonds. I don't think I've ever heard anyone use the word flowered bonds on this. So here's another power of attorney document, and the meat of the document is all contained within about a page. And if we want to look at the banking, once again, we have draw, accept, endorse, and otherwise deal with any checks. So it's like really not built out under the current power of attorney law. Here's another one that's a lot better from 2017, another attorney. The Florida statutes want us citing the banking transaction statutes if you're in Florida and for investments. So powers of attorney that are missing this are flawed and could be subject to headaches at the very least. But when you have the statute cited, you get a whole list of powers that should make these fully acceptable by banks. So that's a definitely acceptable way to do it, because if you look elsewhere, there's not much else about banking transactions. And on this particular power of attorney document, there are initials, but the problem is there's more initials that under Florida statutes has to be had. But for long-term care planning, it says my agent can create a trust irrevocable. So that's great for Medicaid planning, and my agent can make gifts. Good for Medicaid planning. My agent may name beneficiaries. Good for estate planning. And so here's what a power of attorney looks like. Very similar to mine. I'm a very well-respected attorney in my area. Drafted this. Similar to mine. Bank transactions. It cites the statute, and then it says, without limiting the authority, my agent may also deal with my banking accounts, and then have this whole list of language that This is just pertaining to banks. So if you look at just the headers, we have the section for investments, working a business, very specific, dealing with obligations, dealing with spouse, dealing with support, dealing with dependents, paying for funeral arrangements, dealing with your memberships. I've had people who have been unable to cancel memberships because the power of attorney isn't signed, deal with insurance transactions, all types of insurance, safety deposit box, deal with loans, deal with government, tax authorities, health decisions, employment of professionals, caregiver agreements, marital agreements, dealing with even the pets. And then and dealing with the mail. I've seen the post office reject power of attorney for not having provisions such as this. The durable power of attorney document needs to be very specific. So the elder law attorney also disinfects the process there being complaints about abuse or neglect or exploitation or undue influence, because the elder law attorney will produce a sterilized environment to try to avoid those claims, because the elder law attorney will represent the parent, not the person trying to go for power of attorney. And the last step in the durable power of attorney, getting a durable power of attorney for an elderly parent, is to distribute that signed durable power of attorney to the places where your parents have financial relationships. So not everybody just has a bank account, as I've already discussed. People have health insurance, Medicare supplementals, medical claims and disputes, real estate sales, and so forth, credit cards. All those things a power of attorney can control. So you need to distribute that durable power of attorney if we're looking to consolidate accounts or get a handle of your parents' monthly income and expenses, or management of assets and liabilities. That durable power of attorney should give you the keys to consolidate the best is needed and create a very visible, tracked financial money movement scheme that everyone can know, hey, person I named with this power of attorney document is doing the right thing ethically and morally. And the durable power of attorney document will pass all legal muster with all these companies, and you can act on behalf of your parents with little friction moving forward. But it does take work to get to that point. And that's another common mistake, is people underestimate the time required to get all this pushed through the end. If you found this video helpful, I recommend your next steps would be to connect your elderly parent with an elder law attorney local to them, where they can go to the elder law attorney for advice and planning for the durable power of attorney. From there, if you need some more additional context, review videos that I've produced about Medicaid planning and also probate avoidance and guardianship avoidance. Thanks for watching.